So we're going to move on to the Fourth Amendment. So remember the Fourth Amendment says what? We're protected against unreasonable search and seizure. What do they need if they want to search us? A warrant based on probable cause. The word P or the letter P in the word probable cause should remind you of the word proof. To have or to be considered as probable cause, they have to have actual proof, not just a hunch, not like a thought. They have to have actual proof that there is a possibility that they're going to find this thing that they want. We'll talk about some exceptions for warrantless searches, but to get a warrant, you have to have probable cause. Okay, we're going to begin with Mapp versus Ohio. I don't remember. I don't have my paper in front of me. So we're going to begin with Mapp versus Ohio. This is the case that established the exclusionary rule. Mapp versus Ohio establishes the exclusionary rule. We'll talk about what that means. In this case, this woman, Dolly Mapp, there's some bombing threat or something, and the police are looking for a fugitive. And they think that the guy is in her house. So they bang on her door, let us in, we're looking for a fugitive. She says, no, you can't come in, you don't have a warrant. So they go away and they come back a few minutes later waving the sheet of paper, we got a warrant, get out of our way. She, I wish I could make this up, grabs the paper out of their hands, shoves it down the front of her shirt. They push past her, she falls down. They run through her house, the fugitive is not there, in fact. She turns out the paper she grabbed, the paper they were waving in front of her was not actually a warrant. They did not have a warrant to search her house, they lied. And while they're in her house, although they don't find the fugitive, they find some adult reading materials. Yes. So that was illegal to possess such materials. And so she was charged under Ohio state law, and she fought the charge saying that they shouldn't have been able to use that against her because they didn't have a warrant to go in her house. And the Supreme Court agreed. The exclusionary rule says that any evidence found in the course of an illegal search is inadmissible in any legal proceeding. The exclusionary rule says that any evidence found in the course of an illegal search is inadmissible. It cannot be used. It is excluded from any legal proceedings. They can't use it even as evidence for probable cause to get a warrant to come back later. That doesn't work either. No legal proceedings can that information be used. So that's the exclusionary rule. So if it's an illegal search, nothing they find can be used against you, even if they find evidence that you're involved in some horrible drug trafficking or murder or whatever. If they're not allowed to search, then they can't use that evidence. There are, however, lots of exceptions to the rules for warrants. You don't need to know all of these, but if I were you, in that little extra information box, or wherever you want to, I would know about 2 or 3 of them that you can explain. Exceptions to the requirement for a warrant. So some of them are pretty interesting. There's a clerical errors. So a warrant is a document that you have to give to a judge. So the investigator, the detective or whatever, they're going to have to present their proof. Where is their probable cause that they are going to, that this thing that they're looking for belongs to this person or is in this person's possession. And the document includes a whole bunch of detail. They have to identify the name of the person and any other aliases of this person. They have to identify the person's residence address. They have to identify the place to be searched with a really detailed description, like the color of the door, and the brick is like this, and the door is to the left of the garage, and there is like a blue statue out, whatever it is. They have to have a bunch of detail about what this particular house looks like or building looks like. And then they have to explain what they're looking for exactly. And then they have to explain where they think they're going to find it and what evidence they have that suggests that they're going to find it there. All of this goes before a judge, and a judge has to sign off on the warrant in order for it to be valid. So the judge gets to decide how much probable cause is necessary, like how much of that proof is necessary. That being said, judges try really hard to not sign warrants if they're not really sure it's going to work. Because according to the exclusionary rule, what will happen if the warrant is signed, the search is executed, and then after the fact, another appellate court judge says, no, there was not sufficient probable cause for that warrant? Everything gets thrown out, right? So the judge does not want to sign a warrant unless they are really sure the probable cause is good. So it's sometimes they're like, well, judges can just sign off on whatever. You're right, they could. But then if an appellate court judge throws it out and says, no, that wasn't sufficient probable cause, then any evidence that was found in the course of the search is excluded, and that can sometimes be the end of the case, and they can't, prosecute. So this clerical error part, there was a case that involved a search that was in a house that was in one of those like subdivisions where every single house is identical, all the same color, the same build, the same floor plan, the same everything. And so they, the guy had it all written out, the judge approved it, and then when it was being typed up for the copy to give to the actual, this is like when they still use typewriters, the copy to give to the actual police officers to like go and conduct the search, the typist made a mistake and like transposed it was like a 6 instead of an 8 or an 8 instead of a 6 or something. But all the other descriptive information still matched because it was a subdivision where everything looked the same. And so they searched the wrong house, and they still find illegal stuff. So they tried to get the people who had the search conducted on them tried to get thrown out, saying that they weren't supposed to search our house. Our house isn't the one that they were looking for. But the Supreme Court said, listen, the exclusionary rule is to prevent police corruption, like the police from deliberately trying to, conduct an illegal search and then, using evidence against you. There was no deliberate trying to conduct an illegal search. Like the universe wanted your evidence to be found. Sorry, like, too bad. So there's that. Anything in plain view, and to sort of expand on this, any time that the police are somewhere that they are legally allowed to be, anything they can see is going to be considered they're allowed to like search it without a warrant because they're legally allowed to be there. So for example, if you are driving down Texas Avenue and you change lanes without putting on your turn signal and the police pull you over, is that stop legal? Yes, you committed a crime, you broke traffic law, they now have a legal reason to pull you over and detain you. Now that they are legally allowed to detain you, they're standing there at your car window and you've got who knows what in your front seat that is illegal. Do they have to get a warrant to search your car for that information? No. On the other hand, if you had not committed any traffic crime, but the police officer just had a sneaky feeling about you or whatever it was, pulls you over, you haven't done anything wrong, sees the same exact illegal stuff in your front seat, is that evidence admissible? No, because the police had no reason to stop you. They have to have a legal reason to be where they are in order for anything that they see to count. Officer Alanis came, we did a whole week on this in honors. Officer Alanis came in and talked about a case that he did, a drunk driver. The guy was swerving, Officer Alanis pulls him over and then has now probable cause to conduct a breathalyzer test, so subjects him to a search of his breath. And, comes up, way above the legal limit. The guy's sent to jail for the night, and they're trying to charge him, with a DWI. And the guy's lawyer gets it thrown out because the dashboard cam video showed that although he was definitely swerving, in the time that Officer Alanis was following him, he never crossed either of the lane lines. So he was swerving within his lane, but he didn't actually cross the line. Well, the only crime is to cross one of the lines. So Officer Alanis didn't officially have probable cause to pull him over. So then as a result, everything else was thrown out. But Officer Alanis was like, listen, I wish that I'd followed him a few more minutes to make sure he crossed the line or something. But in the end, at the end of the day, I got a drunk guy off the street for the night, and it's not the end of the world. But so that's an example of what that, when the officer might think they have probable cause and then they don't. They can, of course, search if you give them consent. They can, so if you ever say yes, that you can search, and they have permission to search, anything they find is going to be legitimate. If you're at the border, of the country, or in the airport coming from another country, or just traveling within the country, you have essentially no rights to privacy, so they can search you at any time for any reason in any way in the airport. So they can decide that you're the third person that walked through the door, they're going to search their bag. Anything is fine. In the airport, any kind of emergency, a bomb threat is called in, a white tie-dyed looking, spray painted in looking, I can't figure out what Kay's backpack looks like, but it's cool. Is the target, this is where the bomb is supposed to be. The police can come running in here, grab her bag and search it. They don't need a warrant, they don't need to ask her permission. It's an emergency, they can do what they want or what they need to do. There are some interesting distinctions between stop and frisk and a search incident to a valid arrest. So if the police have reasonable suspicion, that's not probable cause. They just have a reason. They think maybe you might be involved in something, or maybe you're kind of just being suspicious. They had calls that there had been break-ins in a parking lot last night, and so tonight they're just kind of patrolling to make sure nothing else is going on, and they see you in the parking lot just walking around. They don't see you breaking into a car. You don't have stolen goods under your arms. You're just kind of in a weird place. Why would you be here? Kind of strange. That's enough. That's reasonable suspicion for them to stop you and detain you, meaning they can stop and talk to you and you're in their custody. So you aren't free to go. That you have to answer their questions. You have to stand there. You don't have to answer their questions. So they can do that, and if they have any reason to suspect they might be in danger, and this is a way low threshold, like they can articulate basically anything, I think I might be in danger, then they can subject you to a frisk. A frisk is not a search. They cannot reach inside any of your pockets, and all they can be feeling for are weapons. So even if they like feel your pockets and they feel some kind of like baggy size or shaped thing with like little, I don't know what, and they think it's drugs probably because they're police officers and they've done this a whole bunch. That doesn't matter. They can't take it. They can't say, oh, this feels like drugs, I'm gonna take this out. They're not allowed to do that. They're only allowed to touch the outside of your garments to feel for weapon-shaped objects, and it's only for their safety. And in fact, they give it back to you when they're done talking to you, unless they have other reason to arrest you or whatever. But if they're arresting you, then they can search your entire person and anything in your control. So if you're arrested and you're holding a backpack or a purse, they can also search the entire contents of your backpack or your purse and everything else. So for part of this, like the ACLU suggests that if the police ever come to your door, like you look through your peephole and the police are outside, you don't know why they're there. The ACLU suggests that you open the door and step outside and close the door behind you, because if they arrest you, they can search anything that was in your possession. So if they arrest you inside your home, like if you're inside your home when they come in to arrest you, well then they can search anything that you could have touched while you were talking to them. So like your whole entry area could now be searched without a warrant. Or if they're sitting at the door, normally like people come to my door that like aren't going to come in, I like open the door and kind of stay and talk to them there, like with the door open. But if they see behind me something that looks suspicious to them and they have, reason for whatever they think it's something bad, then they're able to come in now and to see whatever that is because they were allowed to be at my door. I gave them consent. And so on. So I don't know. I'm kind of the mind that if you don't have anything to hide, you don't have to be that worried about it. But the ACLU suggests that you open the door, step outside, and close the door behind you. Any other questions about search and seizure? Cool. Okay, so just briefly, we want to know that it changes in the school setting. So TLO versus New Jersey, or New Jersey versus TLO, is a case that involved a girl. There was suspicion that some kids had been smoking cigarettes in the girls' bathroom. And I don't remember how they picked this girl. Her initials are TLO. Maybe she was like, maybe. I really don't remember at all. For whatever reason, they think that it might have been her. So the principal calls her into his office and says, hey, I think, there were people saying that there was smoking going on in the bathroom. I want to look in your purse. And she goes, no, you can't look in there. I wasn't smoking in the bathroom. You don't have any proof. And he goes, well, I'm going to do it anyway. So he looks in her purse. He doesn't find cigarettes. He finds marijuana and rolling papers. So then she gets in even bigger trouble. And she appeals to the Supreme Court and says, hey, this was an illegal search. They did not have any proof, no probable cause to search my bag, and therefore the evidence should not be allowed to be used against me. But the Supreme Court says, listen, this is a school, and they have an important objective to like promote order and to promote safety. And so for schools to conduct a search, they need only reasonable suspicion. So I don't have to have proof that you did something. If I have a reasonable suspicion, like somebody told me you did it, or you're acting kind of sneaky, or you're in the room at the same time and nobody else was around, that was my phone was stolen or whatever, then your bag can be searched. You don't have to have enough for a warrant. We can still search you at that level. Although this school's policy, every school I've ever been in, the school board policy is that teachers don't do any searches. Administrators do searches if one is needed. So if I think that, like if my phone goes missing and like someone was in here for tutorials, well I have suspicion, I have no proof you did it, but I have suspicion that maybe it was you because you were the only one in here. So then I might tell the principals that, and then they could search your bag, even if they don't have enough for a warrant, like in the real world. And then these two cases you don't need to memorize, but they both have to do with drug testing of students. Benoni versus Acton had to do with drug testing student athletes. So like all student athletes were put on a list and then they were randomly drug tested. And the Supreme Court said that that was fine. It's not an unconstitutional violation of their, like an unconstitutional search. And it talked about like the safety requirements. So like if you do drugs and then you go and play sports, you can like extra die. It's extra not safe, because like your heart rate could be too high or whatever it is. And so that was like most of the decision for Benoni versus Acton was about like health. So then in Potawatomi versus Earl, they looked at a program that did drug tests for like all students involved in extracurriculars, like they were all subject to random drug tests, because they were basically saying, look, there's no, like if I'm a chess club, there's no extra risk to me for being on drugs. The school shouldn't be able to drug test me. But the Supreme Court again said, no, those kind of drug tests are fine because there's a legitimate educational objective to make sure that the environment is safe and that people aren't doing bad stuff or whatever. Right, so you don't have to be there. So a grayer area is about drug tests for all students, like an entire student body. That, as far as I know, has not gone before the Supreme Court because, again, that part is not particularly voluntary. The other thing that has come up is like about like using drug dogs to search like classrooms randomly. And generally speaking, that has been upheld, although to my knowledge has also not gone before the Supreme Court. Basically, on the basis of if there's any indication that drugs are a problem at the school, then they can search any building under their control. So like, they can't have a drug search of your like car, but they can walk around the parking lot where they're allowed to be with a drug dog. Kind of. Well, they kind of do, but that's way more detail than we need to talk about right now. Some other problems that are like, going before the courts these days are things about like profiling. So like if we know that like drug couriers who bring in like illegal substances or guns or whatever from Mexico, for example, they fit a particular profile. But is racial profiling substantial enough to like be probable cause to promote a search? That's kind of interesting. There are questions about the Patriot Act, of course. There are questions about strip searches. There are questions, the biggest ones these days are about technology. So like if they get a warrant for your phone, it's not just your, old cell phones. They get a warrant for your cell phone and they know like who you called and when. But now they get a warrant for your phone and what? They know who you called and when, but also they have access to your entire email record, including like archives that go back a bazillion years. And probably GPS technology that'll tell them where you've been. And you probably have all of your like social media accounts logged on so they can look at all of that, and all of your friends who are now like part of your social media record, and they can look at your internet search history, like that these smartphones are a much bigger deal. So there are questions about, well, should the warrants now have to specify, like if they're getting a warrant for your phone, should have to specify like what app they're looking in, and like not allow them to look in other parts of the phone. And that's kind of up for debate. Okay, so the Fifth Amendment, I want to remind you that the grand jury clause has not yet been incorporated. The grand jury clause has not yet been incorporated, but all of the rest of it has. So technically speaking, the states as of now are not required to provide a grand jury indictment, although as far as I know they all do at the state level, but there might be some like local, like if you get arrested and you're charged with for some municipal crime, but there's no grand jury there, maybe. But I don't know about that. But I don't know of any states that don't have grand juries. Okay, speaking of, what is a grand jury? Okay, so it's like in any other jury where it's just made up of a group of your peers or a group of citizens who are kind of like you. Talk at your table. What is a grand jury supposed to do? What is an indictment? Go. Stand up or wake up. All right, what is the grand jury trying to do? Decide whether... Nope, not to convict or not. That's a regular trial. Nope, that's what they just said. So whether or not to charge, I kind of heard that at the end of what Josh said, whether or not to proceed, whether or not to formally charge the person and go to trial. So the grand jury is trying to decide whether or not there is sufficient evidence to do that. There's no defense at an indictment, so the only people who present information at an indictment are the prosecution. Usually the defendant doesn't even show up. So they just present information. Here's the evidence we think we have about this person, and here's why we think we should charge them with whatever the crime is. And so the grand jury decides, is there enough evidence to go forward or not? Now, why do we want, why is this protection for us? Yeah, going to court is expensive and it costs time, and so do we want the government to be able to take us to court when they don't have much evidence against us? No, we don't want them to be able to charge us, on trumped up crimes, for no reason, just to kind of be nuisance or whatever, bothersome. On the other hand, the grand jury indictment also is a bit of a protection for the government itself. Let's say that I want to charge Elena with murder. And so let's pretend there was no indictment. I go to trial. It turns out I don't really have that much evidence. So here we are at trial, and she's found not guilty because of insufficient evidence. Can I ever try her again? What if next week I find the murder weapon and the dead body in her backseat? Who knows why I wasn't searching there first? I have incontrovertible evidence I find the week after she's found not guilty. Can I do anything about it? Not a darn thing, right? But on the other hand, if I try to indict her and the indictment fails, there's not enough evidence, the grand jury fails to indict. Can I try again? I can, because she has not yet been formally charged until after she's indicted. So the double jeopardy clause wouldn't apply. So it also helps the prosecution. Just like we talked about the warrants and the judges, they don't want to sign a warrant if they're not really sure that it's going to be worth probable cause. In the same way, really, a prosecutor doesn't want to go to trial until they're really sure they have enough evidence to convict, because if they try once and they fail, they don't get another shot at it. They can't try you again for the same crime. Okay, some other cases. So Green versus the U.S. is not one you have to know, but I just think it's really entertaining. It's about double jeopardy. So it's this guy, and he set a fire that ended up killing this family. And so he goes to trial. He's charged with murder or whatever. And he's eventually convicted of second-degree murder and sentenced to like 20 years in prison or something. But as his lawyer is trying to find appeals, he realizes that under that state's law, murder committed by arson has to be first-degree murder. Like, that's the only option. And first-degree murder carries with it the potential of a death penalty sentence. So the lawyer makes the argument to the Supreme Court. It goes all the way to the Supreme Court. And the argument goes like this. He was found guilty of second-degree murder. That's against the state law. The state law says he must be found guilty of first-degree murder because it was involved arson. So therefore, his trial is flawed and his sentence should be thrown out, because his trial, that was illegal. He cannot be found guilty of second-degree murder under the crime that he was accused with. But secondly, the double jeopardy clause says he can't be tried twice. So once you throw out his first trial, he can't be tried again, so he should go free. P.S. If the Supreme Court bought argument number 1 but not argument number 2, what's going to happen? He's going to get the death penalty. This is a really strong, wager we're making here, but it works in his favor. I'm not sure I'm happy about that, although it's sort of entertaining. You're kind of going like, good lawyer. In any case, the Supreme Court throws out his conviction because of like a technicality, basically, and he's not recharged or retried because he can't be tried at the same time twice. So anyway, there's that. The case you really, really, really have to know is Miranda versus Arizona. This has to do with the idea of not incriminating yourself. So there's this guy, whatever his first name is, Miranda. He's a guy, not a girl. So people hear the word Miranda and think it's a she. He's accused of rape. He's brought into the police station and he's, told to sign it, to write a statement and sign it. And he doesn't realize he has a choice, and so he does. And later, his statement, along with a little bit of evidence, is used to convict him. And his lawyer says, hey, wait a minute. He didn't know. He didn't have to sign that. You shouldn't be able to use it. You forced him to sign it. You never told him he didn't have to. So he shouldn't be able to use that in court. And so the basic question is, is it your responsibility to know your rights, or is it the police's responsibility to tell you about your rights? And the Supreme Court ruled that the police should have to tell you about your rights, that we don't want a system in which the police can exploit ignorance to break the rules, basically. Just because you know that, or you don't know that you have to have a warrant to search, should they be able to search you at any time? Surely not, right? And so that's what requires the Miranda warnings. You've all watched Law and Order. You have the right to remain silent. Anything you say will be used against you in a court of law. You have the right to an attorney. If you cannot afford one will be provided for you. College station's a little bit longer. So there's all of that. That's Miranda versus Arizona. And then finally, for the Fifth Amendment, is Kelo versus New London. This was a town, and they wanted to have a new shopping mall or strip center or something, but the shopping mall needed more space for that development, and so the city uses its eminent domain powers to purchase and then condemn a series of homes along a field or a city center or something, so that they would have, and they're going to tear them down, and so they have enough space to build this shopping mall, or to sell it to this developer to build a shopping mall. And the residents are angry. They say, you shouldn't be able to take our land from us because the Fifth Amendment says that this land can be taken for public use, but you're not going to use it for the public. It's not like a park or a road or a utility center. You're going to just sell it to a private developer and make some money off of it and have, doesn't count. But the Supreme Court ruled in Kelo versus New London that basically anything that the city says is public use is going to count. So if public use means selling it to a private developer to get better tax base, it counts. If public use means that it's an ugly house in the middle of town and we don't want to, have this eyesore in our city center, it counts. They are publicly elected people. They get to decide what is public use. So property rights people are really irritated about it, but community rights people think it's a big improvement because it gives the community, like it makes it before Keeler versus New London, if one family refused to sell, a city could be stopped from creating something that they wanted to put there because one family wouldn't give up the rights to that particular land. Remember that eminent domain, they still have to be paid for it, but they can be forced off. Okay, for the Sixth Amendment, the only case we're going to talk about is Gideon versus Wainwright. There are cases that incorporate all the other pieces of the Sixth Amendment, but Gideon versus Wainwright incorporates the right to counsel. The right to counsel. And while we're at it, would everybody please stand up? Like 4 of you falling asleep. But I do better. Stand up. I want you to, I don't know, you can choose to march in place, or you can jump up and down, or you can bend down and stretch, but do something to physically move your bodies. Physically move, no standing still. Actual movements. The looks on your faces are precious, I just want to tell you that. There we go. You're right. Effort's good. Get that heart pumping. It'll wake you up. Reach up real high. You got it. Yes. Yes. It is. There you go. Once you feel a little bit of, that's probably low blood pressure. Go ahead and sit down. David had a little bit more exciting way to sit down than the rest of us. Okay, we're almost done. It's a marathon, I know. You guys are hanging in there. Don't worry. Thursday and Tuesday are going to be so much more exciting because you're already going to know all this stuff. We're just going to practice. I can do it. Do you doubt me, Josh? Go. That's right. Here we go. Gideon versus Wainwright establishes the right to an attorney being provided for you by the states. This was an old man. He was accused of robbing a vending machine at a pool hall. He stole $20 worth of quarters or something. He asks for an attorney. He's super poor, almost homeless, super poor, and they won't provide him one because the state of Florida says they only provide lawyers in cases where the death penalty is a possibility, capital cases. So they don't give him a lawyer. He does a terrible job defending himself. He goes to jail. And this is an incredible story because in jail, this guy who has a 6th grade education reads from the law library in the prison, decides that his rights were violated. He writes a petition to the U.S. Supreme Court in pencil, even though the rules said in pen, because they didn't have pens in his prison. They were only allowed pencils. His petition was almost thrown out because it was in pencil and not pen. That's a long story. Anyway, writes his petition to the Supreme Court. The Supreme Court hears his case and finds in his favor that in any time, sorry, I was worried I turned that off, that at any time that your liberty is at stake, meaning if there's any jail time at all as a possibility, then the state has to provide a lawyer for you. So they can't just do them for really important crimes. Any crime where you could face jail time, you must be provided a lawyer. For the 8th Amendment, we're going to talk about these together. The one you have to know is Gregg versus Georgia. Furman versus Georgia ruled in 1972 that the death penalty as it was then applied was unconstitutional. Basically, the death penalty was being used kind of arbitrarily. Sometimes when you had this crime, you would get the death penalty. Sometimes you wouldn't. They also thought that it was being used for too light of crime. Sometimes it wasn't even a serious crime you got the death penalty for. So in 1972, Furman versus Georgia said it's unconstitutional, violates the 8th Amendment. 4 years later, so for 4 years, there was no death penalty in the United States. 4 years later, 1976, Gregg versus Georgia, the Supreme Court, Georgia makes some changes, and they say, hey, how about this? And the Supreme Court says, yes, that's fine. So they're just stricter about who can get the death penalty and when it can be applied. Last but not least, I know my music is playing me off. I'll kind of come back and review this on Thursday. But I just wanted you to remember, you already have this information, but please remember about those things in the Constitution that we can't do. They're not in the Bill of Rights, but they're in the Constitution itself. You cannot suspend the writ of habeas corpus. You cannot have bills of attainder. No ex post facto laws, no religious qualifications or religious tests, and you must have 2 eyewitnesses to convict someone of treason. That's how Aaron Burr got off, because he was really smart. Lots of eyewitnesses, but never 2 to the same thing. Anyway, so just make sure that you know that information, and we'll stop there.